Thank you for staying. This is the Entrepreneurial Law Clinic. For those who don't know, the Entrepreneurial Law Clinic is a fantastic program over at our own University of Washington School of Law, helping entrepreneurs in the Seattle area. This segment of the presentation we do as a kind of a series every year on IP. The first session last week was what is IP? Now patents. Next week we're going to be talking about Trademark 101 on Copyright 101. And then the one after that is IP licensing. I do strongly recommend if you have an interest in IP, this is a great series. So please do come back, and if you need assistance as an entrepreneur, please consider contacting the Entrepreneurial Law Clinic. Jake Gober, did I pronounce that right, Jake? Should have checked in first. And Eric Shreiner are here from the Entrepreneurial Law Clinic to talk about Patents 101. Thanks very much.
Great, thank you. Hi everyone, my name is Jake Gober, and along with Eric, we'll be presenting on Patents 101. As the introduction said, we're both third-year law students at UW School of Law in the Entrepreneurial Law Clinic, and we'll talk a little bit about that at the end of the presentation. But for now, we'll go ahead and dive right in. Well, before we dive right in, actually, a disclaimer. This is not legal advice. This is more for general informational purposes only, and we recommend to always consult an attorney for more particularized advice. All right, with that out of the way, an outline of what we're going to discuss today. We'll begin by talking about what patents are generally and why you should care about them, why patents can be important to your business. We'll then talk about patent subject matter eligibility, like what are the type of inventions that fall within the purview of patent laws. We'll talk about patentability requirements, so what conditions must be met in order to get a patent granted. We'll talk about confidentiality and various implications for whether you disclose your invention to the public or not. We'll talk about kind of the logistics and mechanics of filing a patent and getting a patent, what that looks like, what the timeline is of that. And then we'll conclude with talking a little bit about inventorship. So like how to decide who actually should be the named inventors on a patent. It's a little more complicated than common sense might dictate. All right, so beginning, why patents? Why you should care about patents. Before we dive into why you should care about patents, we're going to talk about what a patent is, generally speaking. So a patent is a government grant of a set of rights that gives the patent owner the right to exclude others from making, using, selling, offering to sell, or importing into the U.S. An object or an invention that falls within what are known as the patent claims. I'll discuss more about patent claims later in the presentation, but claims are what define the legal rights that are given to an inventor. And you'll notice that I said it gives the patent owner the right to exclude others. It doesn't give the patent owner the right to practice their invention. This is a common misconception about patents. And the context this most frequently comes up is if you make an improvement to an already patented device and get a patent on that improvement, you might be blocked from practicing that improvement by the prior existing patent. So that's an important thing to keep in mind, that patents the right to exclude others. That's the right that's given to you by a patent. The term of a patent typically lasts 20 years from the date a patent application is filed. That gets adjusted based on delays at the United States Patent Trademark Office and for a few other reasons. But it's, for today's purposes, we'll think about 20 years as the patent term. Another important caveat is that patents are territorial, meaning a U.S. patent only gives you protection in the United States. If you want protection in Japan, you need to go through the Japanese Patent Office, and so on and so forth for other countries. Today's presentation will be focused on U.S. patent law, although we'll note a couple places where it's important to know there's differences in other foreign jurisdictions in their patent laws, because it can affect some substantive rights and some strategy and prosecution based on the differences in the foreign jurisdictions' patent laws. Oop, there we go. So now that we know what patents are, we'll talk about why you should care about patents. This is a list of some of the ways patents can create value. It's not exhaustive. There's many different ways patents can create value in many different circumstances. The first one here, the offensive and defensive protection. Offensive protection, or what I call offensive protection, is probably the most intuitive way you would think of a patent creating value. This essentially means if you have a patent that covers a widget, you can prevent your competitors from making a widget that is embodied or covered by the patent's claims. So you can prevent your competitors from making the product if you have a patent on that product. Defensive use is where you have a competitor who has a large portfolio of patents, and you also have a large portfolio of patents. And instead of spending years and countless dollars fighting each other for patent infringement, you can have a cross-licensing deal. And that's what we call the defensive use of patents. Patents are also an asset. It enlarges investor value. Investors like to see patents because they want to know that once they've funded your startup and you get a product to market, that someone can't just bring a cheap knockoff to market right away. So it's a good way of them ensuring they get a return on their investment. It also provides a vehicle for licensing, which is great. It's a lot easier to license a patent than it is to license a trade secret or a general know-how. While it can be done, absolutely, a patent gives you a defined set of rights that you can license, which is great. And it can also be sold for money and or used as collateral for a loan. Finally, patents are great for marketing purposes. It can give credibility to your technology, and consumers will oftentimes see patent pending or patented technology on a product's packaging and realize that there's some type of innovation going on over the market standard. All right, so with that, I'll turn it over to Eric to discuss patent eligible subject matter. Thank you.
Thanks, Jake. So patent eligible subject matter, there are a few criteria you have to reach to get a patent, and the first one is your invention even eligible to have a patent on it? And that is described under the Title 35 of the United States Code, Section 101, which is patent eligible subject matter. And it allows for a patent on anything that is a new and useful article of manufacture, machine, composition of matter, or a process. So for example, an article of manufacture might be a cheese grater or a bicycle. A machine, I don't think I need to describe that too much. A composition of matter could be a new molecule that you come up with that is not found in nature that is used to fight some sort of disease. And then a process would be, for instance, a method of producing that cheese grater. If it's some new and useful way of producing the cheese grater that makes it more efficient and hasn't been done before, you can potentially get a patent on that process. You can also, as you can see at the bottom, you can get a patent on any new and useful improvement of any of the above. So, of course, someone has made a cheese grater in the past and has a process for making that. But if you can create some sort of new improvement on that method, then you can potentially get a patent there. And in the last 5 years, there have been a few court cases at the United States Supreme Court that have significantly affected the ability to get patent on certain type of inventions, and old patents that were previously issued are being invalidated much more frequently based on those cases. And there's a two-part test for determining subject matter eligibility that came out of those cases. The first thing is your invention drawn to a judicial exception? A judicial exception, essentially, the court decided that there were certain categories of things that are not eligible for patentability. And so that would be, if your invention falls under a judicial exception, you cannot get a patent on it. And then the second part of the two-part test is, does your invention do something more to create something significantly more than just a judicial exception? So there have been several general categories of items that have been ruled not patentable under the judicial exceptions. And you have products of nature, which would be, for instance, if I took a protein from a human and extracted it and purified it and then synthesized it to fight some drug, or as a drug to fight some disease, that would not be patentable because it's a product of nature. It's already found in nature. I didn't do anything more. I just pulled it out of the human body to use it for some reason. Algorithms, you can't take something that is not patentable and say, I put it in a computer and the computer did a few steps and now it's patentable. Essentially, the case in the Patent and Trademark Office says that that's not doing anything new and useful. It's simply just kind of hand-waving over some process that's not patentable initially. Laws of nature are also not patentable. So for instance, the Pythagorean theorem, if you came up with that today, that would not be a patentable invention because I didn't create a new mathematical relationship. I simply discovered that it is true in nature. You're also not allowed to get patents on certain business methods. This is very applicable to financial sectors where they might have a method of when to buy or when to sell stocks at certain times. Again, those are not a new and useful process. It's just kind of a set of rules that determine how to act. And finally, abstract ideas. This one can be kind of tough to understand, but I think a general example would be if I have a data set A and data set B, and I perform some mathematical equation or operation on those two data sets to get each element into some new form of data that I can use for whatever my problem is. That would not be patentable as an abstract idea because you're simply taking two things and performing some mathematical relationship on them. You're not doing anything new and useful to create that final data set. And of course, this has, as on the slide, serious implications for software patents because those cases that came out of the Supreme Court in the last few years have invalidated or led to the rejection of many software patents because the Patent Office has taken the view that many software patents are just taking some idea, some abstract idea, and then putting it in a computer. And you can't simply say, oh, well, my computer can do this operation, so it's a patentable invention because it's some new software. It has to be more than just the idea of putting these two data sets in and getting out a new one because of this idea of multiplying them together or so forth. And I'll go back to Jake for patentability.
Thanks, Eric. All right, so as Eric just talked about, eligible subject matter, that's basically the first box you have to check when you're looking at or trying to decide whether your invention can be patented or not. And it deals with like the general, if it falls within the realm of patent laws, if it's the general type of subject matter that can generally be protected by patents. Patentability, on the other hand, deals with your specific invention and looks at whether your specific invention checks all the boxes needed to be the subject of a patent. So patentability, there's 4 main requirements that I'll talk about today. Novelty, non-obviousness, enablement, and written description. The latter 2 are primarily addressed by the attorney who will be drafting the patent application, so I'll focus more on the first 2, the novelty, non-obviousness part of it, but we will discuss all 4. These requirements are formally examined at the United States Patent and Trademark Office, which is the administrative agency responsible for evaluating whether a patent application should turn into a patent or not. So those 4 requirements that I mentioned earlier, novelty means that in order to get a patent, your invention has to be new. It can't have already been invented. That's common sense, that makes sense. Non-obviousness, on the other hand, means that your invention has to have some sort of inventive step over what's already out there. What this means is it can't be an obvious variation of something that already exists or an obvious combination of 2 things that already exist. And obviousness is determined from the hypothetical perspective of a person of ordinary skill in the art. And a person of ordinary skill in the art, there's no single definition for what that constitutes, like what level of education one would have. It can vary by field, but suffice it to say that it tends to be a lower bar than a lot of inventors might initially realize. So let's say you have a PhD in biotechnology and you invent a new drug that cures cancer, and it seemed obvious to you. That might not necessarily be deemed obvious to a person having ordinary skill in the art. Enablement is a requirement that you have a sufficient disclosure in your patent application that enables a person of ordinary skill in the art to make and use your invention. This is required so you basically are turning over your invention to the public, you're telling them how to use it, and in return for that, you're given those 20 years of the right to exclude others from practicing that. The written description is another requirement that's found in the patent application, and it has to deal with making sure that you describe your invention sufficiently enough to show that you were actually in what's called in possession of your invention at the time the application was filed. This means that you have to actually have invented your invention to get a patent on it, which seems intuitive and pretty straightforward, but you would be surprised at how often it can actually come up as an issue during examination. So to set us up for the rest of the presentation, I want to introduce this term called prior art. This is what the USPTO uses to examine whether an invention is novel and non-obviousness. Prior art is basically anything, either patent or non-patent reference, that is available to the public. It can be as broad as a YouTube video, and it could be as broad as a published thesis. It can also be a presentation. Just anything that makes information public can qualify as prior art. That includes patent applications that ultimately don't issue, so it's a very broad category. So with that, we'll turn it back over to Eric to discuss confidentiality.
Thanks. Yeah. I also wanted to point out, should have at the beginning, but if you have a question, feel free to interrupt at any time and just ask away. Yeah, go ahead.
Can you go back to the previous slide?
Yeah.
One more. One more. Great. So I think for written description, you said that was the one where it had to exist before they file a patent? Was that one? Which one was that one?
Novelty, probably.
So novelty means that your invention has to be new. It can't have already been in existence. Like you have to have invented something new. If there's a prior art document that describes your invention in its entirety, you would get what's called a lack of novelty rejection, and you wouldn't be able to get a patent on that.
Did you also say that something has to, like you have to have created the technology before you can file a patent on it?
No, so I think you're thinking of the written description requirement, which I was discussing, which means you have to be in possession of your invention. It doesn't mean you have to have what's called reduced it to practice, which means like if you have an idea of your invention, that's sufficient so long as you fulfill the enablement requirement of how to make and use it, but you don't have actually had to reduce it to practice to file a patent. Yeah.
Go ahead.
I have a follow-up on that particular question.
Sure.
Thank you, Zinni, for asking, because I was going to wait till the end. Okay, so when you say they don't have to have reduced it to practice, let's say there's a blueprint. If it has been reduced to practice or built a prototype, there's no guarantee that the blueprint will work. I mean, ideally, yes, they've designed something that can be built and works, but are you saying that there's no requirement for the patent that it eventually winds up being something that can be reduced to practice and will work as described? Or is it sufficient that the inventor has the intent, here's my blueprint, I'm like 90% sure this will work, I want a patent, and then one day we'll try and build it. Is that?
Yeah, so one of the requirements of a patent is it has to be useful. So there has to be some purpose for the invention. You can't get a patent on something that doesn't have any utility. That being said, it's a very low bar. So generally, like hypothetical utility in the future, once it gets reduced to practice, is sufficient, and you won't receive rejection on that.
Even if it's only hypothetical utility based on the assumption that it will work as intended to be built. I mean, if it hasn't been built, it's all hypothetical.
Sure.
Right. So there's no requirement that it can eventually be made. It's just, if made, will be useful, is what you're saying?
Yes, I think if I'm understanding your question correctly, yes. So you can absolutely file a patent on that before you've confirmed that when it's built, it works properly. So long as you're meeting all these other requirements that we're discussing, including the enablement, which is you have to describe in that patent application how to make and how to use that.
Right. All right, thank you.
Yeah.
Thank you.
Of course. Any other questions before we, sorry, should have said that earlier, but thank you for your questions. So confidentiality is important because patents, as Jake mentioned, you receive this patent which allows you to exclude everyone else from making and using your invention. But in return, you have to disclose that invention, you have to disclose that process to the public so that everyone else knows how it works, and when the term of your patent expires, anyone else can conceivably take that patent and do the same thing as you did. And so confidentiality is important because in the United States, we follow a first-to-file system, and that means the first person to file a patent application on this invention will have priority to get that patent. And that means, if I invent this thing today and Jake comes along and invents the same thing a week later without any knowledge of it, and Jake files his application first, then I can potentially be out of luck. And then there's the next section in the United States Code is Section 102, talks about this. Sorry, I lost my train of thought. I'll move on to the next slide because it talks about Section 102 in more detail, and it talks about when this is the exception to when something is disclosed. Okay, I'm sorry, I mixed myself up. So Section 102A describes if an invention has been described previously, if it's been disclosed previously, then you cannot get a patent on that invention. And so if, for instance, I invented my invention today and I published a paper on it, and then Jake invented it a week later, even though it's a first-to-file system and he files first, I'd already disclosed it, and that would prevent Jake from obtaining a patent on that invention. However, we'll get to 102B in a little bit. So as the slide says, this is a broad bar to patenting because anything that is out in the public can potentially invalidate your patent or cause a rejection of your application. And so as Jake had mentioned, something as simple as a YouTube video demonstrating how your patent works, or I think we've both read cases where someone's thesis, graduate thesis in Germany was in a dusty old library, and patent examiners found it, and it had been too far in the past, and so they deemed that as a public disclosure because someone in the public could have gone to the library, read the thesis, and known how to make this invention before the inventor filed. And so that was deemed to be a bar to their patent application. However, Section 102B, which we'll now get to, is an exception to this rule when it comes to a disclosure made by the inventor, by the person who's filing the current application. And so here's a little visual, it's kind of a general timeline of the situation where there's what's called a 1-year grace period for disclosures made by the inventor. And so essentially, if I create an invention today and I disclose it, I have up to 1 year from that time, that disclosure, to file a patent application in the United States, and I will not be barred from getting a patent on that invention. Major caveat, that applies in the United States, and this grace period does not necessarily follow, and not that the US grace period follows elsewhere, but other countries don't have similar grace periods. And so there are countries that allow a 6-month invention disclosure grace period. There are countries that don't allow one at all. And so if you have any aspirations of obtaining a patent and going to market in another country and potentially obtaining patent protection in another country, then you should think very long and hard about disclosing at all your invention before filing in all the countries, or at least discussing with an attorney filing in all the countries that you're interested in. However, back to the United States, which is where we're at today, generally, if you disclose your application, for instance, on October 31st of last year, you would have until October 31st of this year to file your application, and you would not receive a rejection for novelty, which would be, if it was more than a year in the past, the examiner would say, this invention has been disclosed previously in its entirety, and you would receive a novelty rejection because your invention would not be new. It had been disclosed too far in the past, or if it was disclosed by someone else.
So does that mean that after that year, to whomever you disclosed your idea to or your application to, are they allowed then to file it as theirs if they had something similar in the works?
No. So those disclosures only apply to if I create an invention and I disclose it, I have up to a year to file that patent application. If I create an invention and I disclose it, Jake can't file for the same exact invention even tomorrow, because the 1 year grace period only applies to the person who invented it, who has the person who made the disclosure can then file the application up to a year afterward. Does that answer your question? I'm sorry. The question was, if I disclose an invention, a year lapses, I can no longer file that as a patent application. Can someone else that I disclosed it to, can they then file an application on the same invention? And the answer is no. So clearly, it's very important to protect your confidentiality, because you risk losing any chance of obtaining a patent on your invention if you don't. So when working with venture capital, potentially, they're going to want to see a pitch, and they're going to want to know why your idea is good and why your business plan will work. And so you're probably going to have to tell them something about it. And for instance, if you need a manufacturer to make a part for your invention, or if you have a client, a customer that you want to sell to, basically any way that your invention could be leaked out into the public at all, you should be very careful of that. And you very likely want to have things such as non-disclosure agreements, confidentiality notices, and prevent at all possible of having anyone in the public hear about or be disclosed your invention. And as I mentioned before, grace periods vary by jurisdiction. So in the United States, it's 1 year. Other countries, it's shorter. And in some countries, there is no grace period. Go ahead.
On the NDA, you say you disclose to someone, and a month or two later, even though they're under an NDA, kind of, you share the information, they publicize it somehow. Does that start the clock on your disclosure as if you had disclosed it at that time, or does the clock start with when you first told that person that then winds up leaking it, or is that a little too abstract?
So the question is, just for everyone listening in, if I disclose my invention to someone else and under an NDA, and then let's say a month later they publicize that anyway, what was the rest of the question?
Does that count as a public disclosure and start the clock on your 1 year grace period, either with when you disclosed it to them or when they violated the NDA and disclosed it to the public?
So the question is, at the point, when does the grace period begin if in that situation where you've, under an NDA, given the disclosure to someone else and they publicize it at a later date? I believe, Craig, correct me if I'm wrong, but I believe that would be the initial public disclosure, the publication there. And so your grace period would start for a year from there. Is that correct? Yeah. Thank you. And now we'll move on to the practical aspects of obtaining a patent, and I'll go back to Jake for that.
Thanks, Eric. All right, so now we'll run through kind of the logistics of filing a patent, the costs, the timelines, et cetera. So the first step is always consult and retain a patent attorney. I say this because there are a lot of intricacies and nuances to patent law. There's a lot of terms that have legal meaning that, frankly, if you're not a patent attorney, you have no reason to know why they would take on the specific legal meaning they take on. So we always advise to either hire a patent attorney if you can, or seek pro bono patent attorney assistance. Step 2 is when you would draft the patent application itself. An application is just a document that it will ultimately turn into the patent if it's found to be patentable. Step 3, you file it with the United States Patent and Trademark Office, where it gets examined. It will be assigned to an examiner at the USPTO who will look at the prior art, make sure that it is novel, is non-obvious, does contain those enablement and written description requirements, and so on and so forth. Frequently, they'll respond and say it's not novel, or they'll make some type of rejection, in which case you have a back and forth with the USPTO and argue why it is novel or non-obvious, and then a patent will either issue, or the patent applicant owner will decide to stop pursuing a patent, and it will be what's called abandoned. This process, it varies a lot by the field you're in. So for simple mechanical inventions, it can be as little as 2 years, but quite frequently this process takes, I have 3 to 5 years up on the slide. It can take longer than that even, which is kind of startling, I think, to a lot of first-time inventors who aren't familiar with the patent system, that it is not a quick process. There's also 2 different types of patents that you should be aware of for today's purpose. I'm actually going to start with discussing non-provisionals first, which is this lower one. A non-provisional is just that's a typical patent application that you file. It gets examined by the USPTO. That's the one that will ultimately issue into a patent if it's found to contain patent-eligible subject matter and meets the patentability requirements. A provisional patent, on the other hand, is you file as a placeholder. A provisional patent is not examined by the USPTO. It does not require some of the requirements of a non-provisional application. On the slide, it lists. It doesn't require formal claims or oaths or declarations. So suffice to say, it's easier to file a provisional patent application. The benefit of a provisional patent application is it creates an effective filing date. So you can then go out and, if you make a public disclosure, you can then not worry about that public disclosure being counted as prior art. A provisional patent application gives you 1 year to decide whether or not you want to file a non-provisional application, and that non-provisional would be entitled to the effective filing date of the provisional application. And again, I said gives you 1 year. You don't have to wait that whole year. You can file a non-provisional claiming that benefit or the priority to that earlier effective filing date at any point up to 1 year. This is really great for a lot of businesses who don't maybe know if they want to pursue patent protection on a type of technology, because it is cheaper and easier to file a provisional patent. So if you do that, you can defer the decision on whether to pursue a patent on that technology a year down the road. So a lot of people take advantage of that. Another perk of the provisional patent, I'll get to you in 1 second, is that it doesn't count against your patent term. So I mentioned earlier you get a 20-year patent term from the earliest effective filing date, which would be when you file the non-provisional application. They do not include that 1 year of the provisional application in that 20-year term. So that's an added bonus. And you had a question?
Yeah, so what's the context of cheaper here? It means how cheap is cheap? Do you have a budget, or what should be one?
Yeah, so good question about the cost. That's coming up in my slides, so I'll answer it when we get there. And if you have any questions after that, make sure to raise them. All right, so,
Could I just make a point about provisionals and non-provisionals? Hello? Okay. Yeah, so typically you can file what's called a cover sheet provisional, where you just slap a cover sheet onto it, and then a year later you file a regular patent application. From a practical point of view, that's not a good practice, because there may be a delta between what you file in a provisional and then what you file in a non-provisional. So it's best practice just to have a regular non-provisional. But if there's a public disclosure that's imminent, product launch, then you might just consider filing a provisional, and then you have up to a year to file the non-provisional.
So, and Greg raises an important point that if you file do file a provisional and then file a non-provisional a year later, claiming the effective filing date, only the stuff that you disclosed in the provisional application gets that effective filing date. So you can add new subject matter to the new non-provisional that you're filing, but only the stuff that was adequately described in the provisional gets the benefit of the earlier date. So thanks for raising that. Yeah.
So just wanted one clarification point. So you were talking about pendency period. I beg your pardon.
I'm just going to say so that other people can hear
it.
We're broadcast on live streamed, and so it gets really silent when people are asking questions without a microphone on the other end. So that's why we pass the mics around, even though everybody in this room can hear.
So just to get a clarification, when you say that the pendency period of 12 months, does that limit the ability to use the attached term patent pending to the invention?
So as soon as you file a provisional, you can attach patent pending to the invention.
Right, but when you say patent pendency period of 12 months, is in your previous slide,
does that limit the use of the term patent pending for only a year?
So if you then don't file a non-provisional and that provisional application expires at a year, then you would no longer be able to say patent pending.
Okay, so, okay. Thank you.
Yeah. All right, so we were here talking about what is in a patent document. So the specification, that's kind of like the main written part of the patent. That's where you have to have the requirements of the written description and enablement, like you're sufficiently describing your invention. There's also a requirement to disclose the best mode of your invention. You can't keep the best way of using or the best way of making your invention, you can't keep that as a secret. However, it's no longer a grounds for invalidating a patent, so it's not quite as important to discuss at length here. There's also what are known as claims, patent claims. This is really the heart of the patent. Claims are what define your legal rights as a patent owner. Here we have on the slide that they particularly point out and distinctly claim your invention. So it basically creates the boundaries of how broad your rights will be as a patent owner. There's also figures in a patent. Figures are great because they can help meet those written description and enablement requirements because they can provide a mechanism for showing elements that may be tough to describe with text. So I wanted to include an example of what a patent claim looks like. We're not going to go through this in detail, but claims start with what's called a preamble. Here we have an amusement device comprising. And as an example of one of those legal or regular terms with abstract legal meaning, the term comprising here, if you change that to consisting, that would drastically alter the legal rights the patent owner gets, and there is no reason anyone should know that unless you're a patent attorney, so that's why it can be important to consult a patent attorney when seeking a patent. And then after the preamble, you list the elements, and that defines what your protection is. So if you have a claim here with 4 different elements, any device on the market if this patent issued and a competitor had a device on the market with those 4 elements, that would be infringing your patent. All right, so now the examination process. I kind of walked through this a little bit earlier, so I won't go through all these top points. But essentially, once you file the patent application, it's assigned to an examiner at the USPTO. Generally, the examiner will have experience or technical background in the same field that you're filing in. That doesn't mean they're an expert. At times, it can be helpful to conduct an interview with the examiner, explaining your technology to them if they're not understanding it. You can also, in different scenarios, involve the examiner's supervisor and or appeal decisions the examiner makes. There's a lot of strategy behind that, whether that can be a good thing or a bad thing, because it is best to have a good relationship with the examiner. So the examiner will write what's called an office action. An office action is just correspondence from the United States Patent and Trademark Office that sets forth the rejections or objections over your patent application. This will include things like, lack of novelty, obviousness, lack of enablement, stuff like that. And then you as the applicant will respond to these office actions, and you have a couple options of how to respond. You can argue that the examiner is misinterpreting either the prior art or the breadth of your claims. You can also amend your claims, which means you're changing the claim language, typically to narrow it, so that your claim language no longer implicates the prior art. So if you have reference A that discloses an element of, going back to the cheese grater, maybe it discloses an element of a cheese grater having a handle, and your claim has a cheese grater with a handle. Instead of arguing that that prior art reference doesn't disclose that element, you can amend your claim to remove the handle or to specify what type of handle it is, for example. There's also what's called final office actions. This is when the examiner makes a final rejection, meaning that it sets forth in motion several different options for the patent applicant. At this point, you can essentially pay a fee and reopen prosecution to continue with the back and forth with the patent office. You can also appeal this decision. You can also abandon the application or file what's called a continuation or divisional application, which is essentially you're filing a new patent application to start prosecution over again, although it can be entitled to the effective filing date of the first originally filed non-provisional application. So what's the USPTO looking at? I know we've already discussed this, but they're looking at the prior art to determine the novelty and non-obviousness. Novelty usually contained in one reference, one prior art reference. Obviousness, the USPTO, the examiners will usually combine two references. And then the timeline for all of this, if you file a provisional, as I said earlier, you have up to 1 year to file the non-provisional. You can do it in less. Office action, the first one, it totally varies by field and by the backlog at the USPTO. It can take up to 1.5 to 2 years, though. Then you're doing the back and forth with the examiner, they send you an office action, you give them a response to that office action, so on and so forth. That can take anywhere from 3 to 4 years. Anyways, it can take up, as we said earlier, 3 to 5, even 6 years for a patent to issue. Again, that's just an average or an estimate. It varies by field of technology that you're working within, complexity of your invention, backlog at the USPTO, but it's not a super quick process. Then you get the 20-year term after it issues, and during that term, you're still having to pay maintenance fees at 3.5, 7.5, and 11.5 years. For the fees, first I want another plug for the international prosecution. If you want rights in foreign countries, there's a mechanism called a PCT that enables you to file a single application initially before filing applications in specific jurisdictions that you want patent protection in. It's kind of outside the scope of the presentation today, so I won't focus on it too much, but it essentially defers the cost of national prosecution, so like filing an application in Japan and the US and Canada and China, it defers that out for 2.5 years.
Yeah, it might just bear repeating that there is such thing as an international application, there's no such thing as an international patent. All patents are national.
Yeah, exactly. All right, so on to the cost. What does this cost? It can be pretty expensive. It varies a lot by the type of technology that you're seeking a patent on. Simple mechanical inventions tend to be cheaper. Complex biotechnology patents tend to be more expensive when you're looking at hiring patent attorneys for that. And that's simply a product of it takes a lot longer to draft a patent application that covers biotech patents. I think it's a stark example. You can have simple mechanical patents that can be just a couple pages long. Some biotech patents run into hundreds of pages long. So it's quite complex and there's a lot of variance. You also have to pay USPTO fees. These are like filing fees, administrative fees, search fees, examination fees, and those are paid to the USPTO. So you're looking at both attorney's fees and USPTO fees. And a breakdown of this I have here. So regular fees due to the USPTO, I won't read off the numbers on the slides, but they can vary a lot. And up here you can qualify for what's known as small entity or micro entity status. This reduces the fees. Small entity status typically is for like small businesses and nonprofits such as University of Washington would, or nonprofits and universities like University of Washington would qualify under small entity. Micro entity, it's typically solo inventors are who qualifies for micro entity status, but there are ways to get these fees reduced, which is nice to have that option. This also doesn't include the maintenance fees, which are due, as I said, at 3.5, 7.5, and 11.5 years after issuance. If you don't pay the maintenance fees, you lose your rights to the patent, and at that time it becomes what's called dedicated to the public, meaning the public is free to use the technology or the disclosure of the patent. Did I? Oh.
Yeah, before we go to that, maybe you want to just mention what's the overall all-in cost of getting a patent?
Yeah, so including attorney's fees, we're looking at anywhere from thousands to tens of thousands of dollars. Typically, on the cheap end, you might be looking at $5,000 for a simple invention, up to $25,000 to $30,000 for a more complex invention. Good point out. Did I answer all your questions? Great. So with that, I'll turn it back over to Eric for inventorship.
Thank you, Jake. We'll just talk a little bit about what makes someone an inventor of an invention. So this is covered by Title 35 United States Code, Section 116, and it's basically the people who contributed directly to creating the invention, even if they didn't necessarily work together or at the same time. And as Jake mentioned, the real meat of the patent, the real legal force behind a patent is in the claims. And so the claims are, the inventorship is determined by the claims. So if I worked on claim 1 and Jake worked on claim 2 through 20, we're both inventors because we both contributed to the invention, the inventorship of the claims of the patent. And as I mentioned, it's based on a claim-by-claim basis, and so everyone covered in the claims, it should be listed as inventor. And also, as I mentioned, you don't necessarily have to work at the same time or in the same place. So toward the bottom it says lab notebooks or notes. It's common if you work for a large company, for instance, in an R&D department, you might work over the course of months or years on a new product, and you have your recorded notes, and then maybe you move on to some new job and someone takes over, and then they refine your process a little more and they make their own contributions. That can be an example of two people invented that are both considered inventors that were distant temporally or geographically. And yeah, this inventorship is it's not necessarily common sense who invented an invention. So it might seem like the person who was the manager of the department had control over the direction, and maybe they seem like an obvious choice for an inventor, but if they didn't actually help conceive of the invention or actually put in the work to invent this new thing, then they might not be considered an inventor. So simply managing the direction of the group or the invention itself is not enough to be considered an inventor. And let's see. Yeah. And patent applications are filed in the name of the inventors themselves. So if Jake and I help invent this new, let's say we work at Amazon and we invent the mail carrier drone, the invention will be filed in our names and then typically listed, as through Amazon, or Amazon would own the patent because part of our employment agreement at Amazon would assign our inventions that we created while we were working there to the company. And as I mentioned, the assignment would typically be through an employment agreement, and it should be very explicit. This is a common issue that you see with startups where I come up with a concept and I hire a couple software developers to help work on my app, and then I don't get anything in writing with them, and they build out this website or this platform or this idea, and then suddenly maybe they invented this idea, maybe they own this intellectual property, because I never got it in their agreement or their contract that those rights would be assigned to the company. So that's something that's very important to consider if you're developing a product and developing an invention and you're bringing in outside help to work with that.
Do you know?
Will you grab the mic?
Yeah.
Thank you.
Do you know if that provision in corporations with respect to owning or having the employees turn over their portion of the patent to the company, does that only apply during the, we'll call them operating hours or when you're at office? Or if there is a non-moonlighting condition in the employment agreement where you might create things outside on, let's say, ABC Consulting, does ABC Consulting also fall under the purview of the corporate patent thing?
That is a great question, and the classic lawyer answer is it depends. It depends on your employment agreement. It depends on state law, and typically, to be safe, you should always read your employment agreement if you're working for a company and you want to, try and invent something on the side, because employment agreements can cover all of that, should cover all that, and you should get a sense of what your responsibilities and your rights are with inventing things on the side. There are a lot of companies that will say that anything that you create while you work for that company is owned by that company. Depending on where you are, that general blanket ownership can or won't hold up. A lot of places will say if you are at work or you're using work resources, all of those creations will belong to the company. And I would say that's generally more enforceable. You know, if you're using a customer list or if you're using some proprietary technology from your day job to help invent this new concept, it looks a lot like you're doing it with the direction of or under the supervision of your company. And that kind of stuff would typically be owned by the company. Does that answer your question? Thank you. And I think we got through most of this. Yeah. So we'll give a quick. Go ahead.
One point, yeah. So inventorship is not the same thing as authorship, right? I mean, so typically you see, you know, a bunch of names on a paper that are put there. For inventorship, it's different, as was well explained. So there, the issue is, did you contribute to the conception as it is claimed? That's the legal test. So it's a narrower test than it is for authorship. The second point regarding inventing on your own time, I think the case law is that it comes down to where you're using resources of the company and what your employment contract says. And I've seen different contracts that, you know, that are pretty loose and very generous to ones that just say, hey, if you work for us, we own it. And so it's a spectrum in terms of what it is. But if you're using your own laptop on your own time, you'd have a stronger argument than if you use your company laptop or, you know, working while you're in your office. So.
So I'd like to give a quick plug to both the UW Entrepreneurial Clinic and then also the Washington Pro Bono Patent Network. First of all, Entrepreneurial Clinic, that's why Jake and I are here today. That's why Jake and I are here today to present, is through the clinic. Professor Jennifer Fan is here today as well. She runs the clinic and does a fantastic job. Primarily, we help with startups start their businesses. And so there are students on the corporate end who will help you form an entity or work on a contract for employees or independent contractors. And then you have guys like Jake and I, ladies as well, like Jake and I on the IP end, who will help with the patent, trademark, trade secret, copyright protection, things of those nature. And so we try to give kind of a holistic list of recommendations on how you should go about forming your business to be as protected as possible. And then secondly, the Washington Patent Pro Bono Network is it's a teaming up of the University of Washington and the United States Patent Trade, USPTO. And basically, there are attorneys in the area who will give their time for free pro bono, and they'll help low-income inventors patent inventions that they create. And so if you have a business that you'd like to start up, or if you have a patent that you think you would like to file for, we do encourage you to apply for both the Entrepreneurial Law Clinic, just for general business, which can include the patent stuff, or if you just have patents, we would encourage you to apply for the Patent Pro Bono Network. And the Entrepreneurial Law Clinic information is in the slides. The Pro Bono Patent Network is not. So if you're interested in applying for the Patent Pro Bono Network, please email wapatent, WAPATENT, at uw.edu. Thank you. And I think now we have time for some questions.
I do have another question. So
can you give them? Yeah. Thank you.
Going back to your area of inventorship. So some of us inventors will go ahead and carry on around our Inventors Logbook, where we'll go ahead and create and spec out and describe some areas, date, and all that other good stuff. How defendable is that? Let's say, for example, before we actually get into the patent process officially with the government, whereas with somebody else who might have already gone through it, if we already have prior use or prior documentation of a similar or like idea.
I think I might not be understanding your question correctly, but I'll try and answer it and let me know if I am.
Sure,
so if you have a logbook of all these things that you've invented and that you keep close to your chest, and someone completely unrelated comes up with a similar or the same product and they file a patent application on it, then you would not be listed as an inventor on that patent. That would essentially be a parallel invention, and they would then have priority for that patent over you.
And the fact that you have this disclosure in your notebook that's predated to the other patent filing, you cannot use that to overcome the other patent filing, because the U.S. is what's called a first-to-file country, which means whoever files that patent application first is the one who who will get those rights. With some limited exceptions, when you get into things called derivation proceedings, it's trying to determine, or do you want to jump in?
Yeah, I was just about to say, that is true today. Before 2013, we had a first to invent system where you could actually use those notebooks to get priority, and you had interference proceedings. That's no longer the case. They kind of morphed into derivation proceedings and all that other stuff. So today, you're right, it's a first to file system, and that's the world we live in. Before, it was a different world where inventors would keep really close and good notes, because then if you got into a dispute, who conceived first, and did you reduce it to practice, and was there diligence between the two? You got into all these kind of arguments and legal proceedings, and that's kind of subsided. It's morphed into more of a derivation proceeding. So,
also as a side note on that, kind of the international flair is one of the main reasons the United States went to a first to file system, with some exceptions, is because basically every country in the entire world is also already and has been on first to file systems for a long time. So U.S. was kind of coming into accordance with the rest of the world.
So kind of related but unrelated, and we'll get to this next week in the Trademark 101. I understand that there is a prior use element to trademark, and I don't know if this is your bailiwick or not, but does the first to file also apply similarly in the trademark world, where if somebody's already filed in 2018, but I've got a prior use documented stemming back to, let's say, 2000 of a mark, does that also apply, do you think?
For trademark law specifically, you're asking? Yeah, I'm sure they'll get into this next week, but the answer is yes. The prior user retains their rights, but those rights can be limited by someone else filing on that mark. And what I mean by that is they can't take away the rights you get, but you might be limited from expanding geographically, or you might be limited from expanding into other product markets if you haven't filed on the mark and you're solely relying on what's called common law protection of the trademark. But yeah, I don't want to step on the toes of next week's presentation.
It just started to freak me out a little bit because I have a situation like that. So.
Okay. Yeah. So definitely come next week.
Yeah. Any other questions? All right. Thank you so much for showing up today.
Yeah, thank you.